Honor, today is the date and time set for the probable cause conference. However, I have spoken with Mr. Edwards, and there appears to be a breakdown in communication between Mr. Edwards and our office. He does not believe that we are fighting in his best interest, and we are asking that our office be withdrawn because I do not believe that this breakdown is something that's going to be. So we're asking to have our office withdrawn and new counsel appointed.
Mr. Edwards, what's the problem?
Beg your pardon?
What's the problem?
I believe the attorney can answer it better than I can legally.
Can what?
He can answer that better than I can.
Are you asking to have counsel removed?
Yes,
Why?
it's been a breakdown in our communication.
What's that mean?
We disagree with things we can't see eye to eye. I have yet to go over with him the discovery, everything that this case is about.
I don't know what that means. You haven't had a chance to go over it with him?
He hasn't went over it with me.
Pardon?
He hasn't went over that with me. Any of my requests is, matter of fact, he had told me that I could get my, transcript or the paperwork. I don't know the legal terms to put it in today.
That you could get your discovery today? Is that? You're not going to go through trying to pick attorneys, Mr. Edwards. I think we went through this before. Yeah.
I'm so sorry. Ms. Hightower.
We're going to have to see a motion. I don't understand what this is about. We went through this the last time. I told him to listen to you. You didn't want to listen to him?
I did listen to it.
And so what's the problem?
That's why I said that he can explain it better, because like you said, there's a breakdown. You can't understand it from me, and so maybe he can tell you in the terms that you'll understand.
Mr. Brown, without
Revealing,
yes. What's the problem?
Your Honor, I've had several visits with my client, and the upshot is he has made it clear that he does not believe that our office is working in his best interest. He does not believe that we are trying to help him in this case.
Right. My question is, in your opinion, is there a valid reason for his insistence in not wanting your office? I don't need to know the specifics. I'm just asking your opinion, because it just sounds to me like he just wants to complain.
Well, of course, Your Honor, from my point of view, there's not a valid basis for what he's saying, but there is the fact there is a breakdown in communication. He simply will not take my guidance or my advice, and whether or not it's based on anything that's substantive or real, the fact is, if he's not taking my guidance, not listening to me, and not hearing what I'm having to say, then that constitutes a breakdown in communication that I can't overcome.
So he's making it impossible for you to work. Well, you don't have to say that. That's my...
This is actually a fascinating legal moment. Courts usually do not allow defendants to keep swapping attorneys just because they're unhappy. But there's a legal standard called a breakdown in communication. If the attorney and client can't work together at all, no trust, no cooperation, then effective representation becomes impossible. That's why the judge is skeptical here, but still leaning toward allowing the withdrawal. Think about it. Would you want a lawyer representing you if you didn't trust a single word they said?
Picking and choosing his attorneys. I'm going to allow it this time. Mr. Kilowald's been appointed to represent him.
All right, thank you, Your Honor.
All right. Esteban.
Yes, it's a motion for bond reduction. I think he says he doesn't have a prior record except for one OUIL, and that he came here in compliance with the court order, except
After drinking. Yeah,
he had been,
which he's not supposed to be doing.
right,
So why would I lower his bond?
I think there's a chance that he'll prevail on the underlying case, the domestic violence. And I think lastly, having been in here, look, the man's in shackles. For a person who's really not habitual or a regular, he's in handcuffs and shackles. I think he learned.
That's the way we transport.
I know, but I think he learned his lesson.
Yeah, I did.
You want to speak? Speak for yourself. Speak.
Yes, Your Honor. I learned my lesson. Then plus, if I want to get out so I can try to take care of my business at home, and I could, if it could, I would pay $500 to get out. But that's
He's saying he's requesting 5,000, 10%. That's what he's trying to add. Thank you.
Go ahead.
That's all I have.
Your Honor, I did have an opportunity to discuss the bond violation with him. He did appear remorseful and understood when I explained the violation, alleged. He did admit to the violation and would have no objection to being placed on a sober link or a scram tether of any kind to ensure he maintains his rights.
Well, I agree with that. And in addition, I'm sorry, I forgot one fact. He has family support. I've spoken with his sister since I've been here.
Clarify one thing for the record. He does have priors. He has a DV from 2010 as well as multiple OWIs.
Well, I heard of one.
Well, the one from 2003 is the second, so you don't get that the first.
Oh, I didn't know nothing about that.
I don't have any.
And there it is, the moment the bond request collapses. Bond reductions depend heavily on trust. The court has to believe the defendant will follow the rules if released. But here's the problem. He allegedly violated the existing bond by drinking alcohol, which the judge had already prohibited. Then the prosecution reveals additional prior offenses the defense didn't mention. That combination is almost always fatal to a bond reduction request. So let me ask you, should courts give people another chance after a bond violation, or is the judge right to say, you broke the rules once, so the bond stays?
Can't make it. Go ahead.
Your Honor, my name is Alex Parks. I'm requesting to practice pursuant to...
Tell your client to take his hands out of his pockets, please. Go ahead.
I'm requesting to practice pursuant to MCR 8.120 under the supervision of Mr. Gaddy.
Mr. Gaddy explained to you, you don't yell names in the courtroom.
He did.
That will never happen again,
It will
correct?
not.
Thank you. Permission to practice is granted.
Yes, Your Honor, that's my fault.
No, it's not. I know you would have taught her better. I've known you a long time, Mr. Gaddy. It's all her responsibility. Go ahead.
Mr. Button, please state your name.
Daniel Button.
Thank you.
Your Honor, we're asking for an adjournment in this matter for time to reach a resolution.
Probable cause conference without objection, June 27, 2024, 9 a.m. Bond continued.
Thank you.
Thank you.
Nicholas Kozitza.
Who?
Nicholas Kozitza. Kozitza.
How's that spelled?
Kozitza.
Oh, proper spelling. Okay, go ahead. Where are you from? Never mind. Go ahead with your spiel.
Nicholas Kozitza. I'm requesting permission to practice pursuant to Michigan Court Rule 8.1.
Are you reading that?
Yes, I am.
You couldn't memorize it?
I have it memorized.
You do?
Yes.
All right, then look at me when you're saying it.
Nicholas Kozitza, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision.
Whoa. Whoa. No, you gotta start again. That's not how our court rules are set.
Oh, Michigan Court Rule 8.120
Thank you.
under the supervision of Assistant Public Defender Torcio Feaster, representing Mr. Michael White.
Where are you from?
I am from originally California.
Oh, that explains it. All right, where are you in school?
MSU Law, Michigan State.
Oh, a Spartan.
Yes, sir.
Did you know that?
I did.
You did? And you still let him get up here in front of you?
I think we said we tested on the fire.
I'm a terrapin. I don't really like Spartans much.
I won.
All right, permission to practice is granted. This poor gentleman's been waiting.
Thank you. Mr. White, please state your name.
Michael White.
Thank you, sir.
We've spoken with Mr. White and we'd like to set this for preliminary examination.
All right, is all discovery complete?
Yes, Your Honor.
Yes.
All right. And would the people have their witnesses available on the 18th?
We'll do our best.
Preliminary examination in person will be June 18th, 2024, 9 a.m. That is before Judge Svalvo. All right. We'll continue. Thank you. Thank you, sir. It's funny. It's funny. So who's that next to him? I know. So he goes back there to sit down. She's like, oh, good job. She didn't know. All right. Anyway. And no, that was great encouragement. And he like nodded, but yeah, I know. All right. Anyway. That's it for me. Yes. All right. Court's going to stand in recess. We'll come back at